in the matter of petitioner Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
You always tell the truth.
Well, that turned out to be a lie. Anyway, hey guys, and welcome back to the channel. Today, we're diving into the next chapter of the Lindsay Dineski saga. And while this is technically part 4, things took a bit of an unexpected turn. Instead of continuing right where we left off, we've got a sudden plot twist. Lindsay was recently arrested for resisting arrest after refusing to step out of her vehicle when instructed by a police officer. Now, refusing to get out of your car is always a terrible idea. But doing it while you have an active warrant out for your arrest is practically guaranteeing the day will go downhill fast. I've already submitted a request for the full body cam footage. But until that gets approved, we're going to take a slight detour. So, while we wait, let's shift gears and enjoy something that never disappoints. A full-blown, sovereign citizen-style meltdown captured inside its most natural environment, the courtroom. These moments always deliver a fascinating mix of confusion, confidence, and complete rejection of reality. And today's example is no exception.
We had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no for service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yeah, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
That's actually true in general, but in Lindsay's situation, it doesn't even matter because she moved out of her previous address and never bothered to update the court with her new one. Under MCR 2.107, service is considered valid when it's sent to the last address the party provided in their official court filings. In plain English, if you move, whether by choice or because you were evicted while doing your best sovereign citizen impression, you are still legally required to notify the court of your new address. If you don't, the court is fully within its rights to serve documents at your old address, even if you're nowhere near it anymore. The judge and staff step away for a few minutes to confirm that service was handled correctly. And when they return, just watch how seamlessly Lindsay jumps right back into her routine. She doesn't miss a single beat. It's like she's been rehearsing her next move the entire time. They were out of the room.
A trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring, and this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail. You were interfering with his mail, Ms. Nerswick. And wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do
appears
not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Aw, that's adorable. Lindsay has reached the point where she's basically the auxiliary of imaginary punishments, handing out death penalties to anyone within earshot. You get a death penalty. You get a death penalty. Everyone gets a death penalty. She's even directed that same dramatic threat at me more than once. And honestly, at this point, I think we should all treat it like a badge of honor. If Lindsay has declared you worthy of her ultimate sovereign citizen punishment, congratulations, you've officially made the list. Now, in the next part, things get even stranger. The court staff steps away and leaves her alone in the virtual meeting. And instead of waiting quietly like a normal person, she immediately launches into a full-blown conversation with herself. No audience, no judge, no attorneys, just Lindsay carrying on as if she's presenting an argument to an invisible courtroom. It's a perfect example of how deep into her own world she truly is. And it only gets more surreal from here.
This is also a bill of payment penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm going to put you in the breakout room with Ms.
This is a violation of my Fourth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Lindsay has this remarkable talent for talking, nonstop. She genuinely never pauses. The judge steps away for just a moment, then comes back and decides to push the hearing back a few hours while they wait for a prosecutor to join. Under normal circumstances, routine matters like this can be handled perfectly well without a prosecutor present. Courts do it all the time, but with Lindsay, everything becomes 10 times more complicated. She turns even the simplest procedural step into a maze of confusion, interruptions, and self-invented legal theories. The judge knows that trying to move forward without a prosecutor would almost certainly lead to more delays, more arguments, and more unnecessary chaos. So instead of fighting through yet another round of sovereign citizen theatrics, the court wisely hits pause and reschedules. And honestly, given the way Lindsay operates, That might be the calmest choice anyone could have made.
Okay, we don't have a prosecutor. I'm putting this over. Can we? I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And I need
Deputy, did you hear me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in
I don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about
Prosecutor.
2:30?
I want to say something. You guys are.
Miss Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here
no prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here.
So
Mr. Ness, please
let's say
be quiet.
1:45. I don't have a
You
prosecutor.
need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 145.
Okay,
All right, we'll
I'll be
see y'all
back
back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that that hearing would be done by 2:30 or are
I'm
we
waiting
looking
on a
at
prosecutor.
2:30?
I can't.
Well, it has
The
to
record is
Your Honor, I
going
have
now.
a 2:00.
I can't call it. So
Prosecutor, I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why won't you
Okay.
answer any of my questions?
Your Honor, I'll see you at 1:45. Thank you.
Sounds good.
You just ignore my question.
Well, then maybe stop asking pointless questions in the first place. After a short break, a few hours pass and the prosecutor finally arrives, allowing the hearing to resume. With everyone now present, the court is ready to move forward, or at least try to. Given the circus level energy Lindsay brings to every proceeding, what should be a simple continuation quickly turns into another round of confusion, clarifications, and attempts to steer the conversation back to reality. But with the full lineup in place, the judge does their best to guide the hearing toward something.
I believe arraignments can take place without the prosecutor's office, but
I kind of thought so. I did start, but for this particular one,
Yeah, this one, I think.
considering the fact that
yeah,
I've been, we needed you here. That's why I started off, and I was like, oh no,
Leslie, as far as the allegations go, I do believe that this is a bench-born arraignment.
hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right. Miss Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of Mr.
All right. Miss Fort Williams, you had an opportunity to speak with Miss Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right. Miss Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter, and so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation, which 2.516.
No, I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Miss Dineski. Let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. That's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
What are you even talking about? If you genuinely believe your rights are being violated, then you should absolutely want everything to be handled by the book. Proper procedure is the exact thing that protects you in situations like this. And what makes your argument even stranger is that you've already cited multiple Michigan court rules during this hearing. That means you not only recognize the legitimacy of those rules, but you're actively trying to use them to your advantage, even while representing yourself. So, whether you admit it or not, you clearly do want a procedural process. You're relying on it. And the fact that you're quoting court rules while simultaneously claiming the system has no authority over you just makes the contradiction even more obvious.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Mr.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
Your court rule. He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also.
Dineski,
ma'am, the reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate to.
I'm proceeding sui juris in persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do not want an attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
what else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge this at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is an arraignment.
Procedurally, there are things we have to do, Mr.
No, not of my rights.
You know, you've brought up several different case laws in your filings today. So clearly, you've put at least some effort into trying to sound legally informed. But it seems like whichever imaginary law school you attended, let's call it the Williams Fried Chicken School of Law, conveniently skipped over one very important case. Pennsylvania v. Mims. That case makes the rule crystal clear. If a police officer gives you a lawful order to step out of your vehicle, whether it's a U-Haul, a sedan, or anything else on four wheels, you don't get to decline. You can't debate it, reinterpret it, redefine it, or sovereign citizen your way around it. The officer has the authority to require you to exit, and your job in that moment is to comply. So while you're busy pulling case law out of thin air, it might help to start with the ones that actually apply to the situation you're in. This is one of those moments where understanding the basics could save you a whole lot of trouble.
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent, or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on the respondent to do so.
All right.
It would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, she doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this. Ms. Dineski, you've been advised of your right to have counsel. Is that correct?
No, I have a right to assistance of counsel.
All right.
Okay.
Do you want assistance of counsel, Ms. Dineski?
She can assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now, but I do appreciate her very much.
So you asked for the assistance attorney, Ms. Fort Williams.
No, I didn't ask for it. She gave it to me, and I accepted her opinion, but I don't, the law does not agree that I can't ask for this to be dismissed in an arraignment, because Lufkin v. McVicker
said that. So your request for dismissal is denied.